Welcome back to part two of the business of music. I'm going to start off with a quick quiz. This is a hands in the air type quiz. So I'm going to show you a number of pieces of content, and all I want you to guess, it's a 50-50, is what we are looking at protected by copyright? Okay? We'll talk about Barbados copyright, although actually the answers to these questions will be pretty much the same in most countries that you would go to. So I'm going to show you some content, some art, and I want you to just put your hands in the air if you think it is protected by copyright. Okay, so hands in the air if you think that what we're looking at has copyright protection. So let's start off with this. This is a news story that I wrote last week. For my daily bulletin, the CMU Daily. It's actually an article about copyright. Have you been following the Led Zeppelin song theft case in the US? Very interesting case, a very grey area of copyright law that I'm not intending on talking about today, because plagiarism is a tricky area of copyright law when things sound alike. But that's not what we're here to talk about. We're simply asking, is this news article protected by copyright? So put your hands in the air if you think it is. Is this protected by copyright, this article that we're looking at? Okay, so the yes-no question. So hand in the air if you think yes. You don't need a C symbol to have copyright protection. Okay, you're right if you put your hands in the air. This is protected by copyright. I own the copyright in this, so if any of you want to infringe it, I will see you in court and sue you. Okay, so I am the copyright owner here. So basically, there is copyright in anything written down. Anything written down is protected by copyright. So literature is protected by copyright. News reporting is protected by copyright. The manual that comes with a new washing machine is protected by copyright. Anything written down and published has copyright protection. In terms of this story here, the facts are not protected by copyright. Okay, so numerous news agencies across the world reported on this story. The facts are not protected by copyright. You could take my story, rewrite it, put it on your website, your blog, whatever, and that would be fine, because the copyright is not in the facts. However, if you were to cut and paste my story and put it on your website, that's copyright infringement. You could link to it, and that wouldn't be copyright infringement. If you paste it on Facebook, if you were to paste it on Facebook, technically that is copyright infringement. Technically, I could sue you. Technically, I could cease and desist you. Realistically, I'm not going to. Okay, so when people share things like this, now, there is, in most copyright systems, an exception for quoting. Okay, and the copyright rules around quotes are a little bit of a grey area. Okay, so if you were to say on your website, CMU's Chris Cooke said yesterday, open speech marks, a jury yesterday ruled that Led Zeppelin did not rip off the Spirit, blah, 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 then you could probably get away with saying, oh, well, that's a quote, and there's an exception covering quotes. However, if you were to put my entire article and just put at the top, Chris Cooke said yesterday, and then the entire article, and then you said, oh, well, that's fine because it's a quote, I would go to court and say, no, that's not what the quote exception is for. That's exploiting that exception, and so that is copyright infringement. The little C symbol, okay, that is not what gives you the copyright. What it is it's stating who owns the copyright. Okay, so at the bottom of my website it says C in a symbol, FreeCM Unlimited, which is my company. Okay, and that is simply stating to the world, I own the copyright. Because remember, there's no copyright registration. There's nowhere I can go and tell the world that I own this copyright. So that's me saying, I am the copyright owner. On a CD, under every track, it says C, Universal Music. That's Universal Music saying, well, actually, probably it would say C, Sony ATV. Sony ATV claiming they own the publishing. We then have a P in a thing, which is short for phonograph, and that's the Universal Music saying, I own the P. It's confusing, because you'd think the P would be for publishing, wouldn't you? But usually the C symbol is by whoever owns the publishing, and the P by whoever owns the recording. So anything written down is protected by copyright. There is the quoting exception, although, as I say, that's a limited exception. It doesn't mean that you can just run my entire article and pretend that it's a quote. And things like, sometimes people think that if you credit it, that's fine. or if you link through to my website, that's fine. And technically, that's not an excuse, okay? And people often think that with photographs. Nab a photo off Google Images, and if I credit the photographer and link to their website, that's fine. It's like, that's not fine. It's nice for you to credit, it's nice for you to link, okay, but that doesn't mean that you're not infringing copyright. The issue is, as we talked about earlier, if you were to put this on your blog and you linked through to my website, well, there are SEO, search engine optimization, okay? My Google ranking goes up if you link through to my website. So for SEO reasons, I'll just ignore it, okay? And it's like, oh, we get an extra link, ups our Google ranking, whatever. But if the New York Times was to put it on their website and put loads of advertising around it, then I would be like, well, hang on a second, no, that's not okay. And I'm going to issue a cease and desist and say, take it down or I'll sue you. And then if they don't, I'll sue them. I mean, realistically, I wouldn't, because I couldn't afford to fight the New York Times in court, which is always the limitation of copyright that we alluded to earlier with trademarks. But in theory, I could, because it would be copyright infringement. In terms of the quote at the bottom from this lawyer in California who gave a quote, who owns the copyright in that? And that depends how the quote came about. If I had had a phone call with Michael Keyes, and then I'd written up the conversation, I would own the copyright, because I had set the words in stone. However, if, as what did happen, this lawyer emailed me his quotes, he owns the copyright, because he set the quotes in stone. So there isn't copyright in spoken word. There isn't copyright in what I am saying now, okay, because it's not fixed, it's not written down. Actually, it is recorded, so I could possibly try and get it on that basis. But copyright is in things when they're written down and fixed. So with quotes, the copyright usually belongs to whoever fixed the quote in writing. Okay, but the basic rule is, if it's written down, it's protected by copyright. Tweets are protected by copyright. There are some people who would disagree with me on that point, but I would take that to court. I think a tweet is protected by copyright. There are some test cases in the US. People like BuzzFeed, who embed tweets with photographs. There are some photographers who are going to test that in court, because there are photographers who are saying, just because you're embedding a tweet with my photo, that is still copyright infringement. I think they will win if those cases ever get to court. BuzzFeed will probably write a check to make it go away. But if it gets to court, I think they'll win. So anything written down has copyright protection. What about this? Hands in the air if you think yes. Is there copyright in that? Oh, people are... Okay. Bit of a... there isn't copyright in names, okay? There's no copyright in names. This is where trademarks come in, okay? So if you want protection for your name, whether it's your real name or your company name or your brand name, that is where trademarks become important, okay? Well, you're saying it's my logo. However, my logo is CMU written in trebuchet. So you're right. If I had commissioned an artist to create a beautiful rendition of the letters CMU in an original form, then there would be copyright in the logo, because it would be a work of art. So there is copyright in the McDonald's M, because the McDonald's M was created by an artist and it's a work of art. You can also trademark logos, so you would trademark it as well. But because all I've done is written CMU in trebuchet, there's copyright in trebuchet, the font, okay, but I don't own that. I've merely licensed that. And because I've just written out my name in somebody else's font, then there wouldn't be copyright in it. So therefore, if I wanted protection in either my name or my logo, I would have to get a trademark for it. And as we discussed earlier, I'd have to get a trademark in every single country where I wanted protection. Although I could get the whole of the EU, bar the UK, as of this week. So names are protected by trademark, not copyright. What about this? Hands in the air if you think yes. Is there copyright in this? Okay, this is why we're here. Yes, there is copyright in lyrics, and that's why we're here. Copyright law generally treats lyrics as just another literary work. Okay, so it treats lyrics just like it treats journalism and literature and marketing copy. It's just something else that's written down. So generally speaking, lyrics aren't getting special protection. They're just treated as another literary work. But lyrics have copyright protection. What about this? Yes, if you think yes. Okay, is there copyright in this? Yes. I don't know why some of you haven't put your hands up. Yes, yes, there is copyright in this. That's the other reason why we're here today. two important things to say about this. Firstly, the copyright in the music is separate to the copyright in the lyrics. Okay, so copyright law treats the lyrics and the music as two separate things. So if you have a song with lyrics, there are two copyrights there. Okay, there's a copyright in the music and there's a separate copyright in the lyrics. If you are collaborating on that song, if one of you writes the lyrics and one of you writes the music, technically you each own your own copyright. Or you could just say, well, we'll just take 50-50 of the entire song copyright, and that would be for you to agree. The other thing to say about this is, actually, there are two copyrights there. There is a copyright in the actual lines and dots on the page. Copyright law would call that a typographical arrangement. There is then copyright in what that represents. And it's the latter that we are really interested in here. Okay? It's not the dots and lines on the page, although that is protected by copyright. It's what that represents that we are interested in. Now, this one is going to involve your imagination. I want you to imagine that this video is now playing, and that we have music playing, and we have moving images, or you can just, probably almost can't see that. It's the Thriller video. So, okay, this is Michael Jackson in the midst of the Thriller video. It's a lot clearer on my screen than on that screen. So if this video was playing, is there copyright in this? Okay, is everyone saying yes? Okay, now, this is interesting because there are multiple copyrights at play here. Okay, so I think there's at least 5, maybe 6 copyrights in this video. They are all separate copyrights. So does anyone want to shout out, what are the 6 things that have copyright protection in this video? Okay, so the lyrics, first of all. The music. Okay, the video as a film. Okay, when you say performance, what do you mean? Okay, so choreography has protection. The other 2, if we take it to 6, is the sound recording has protection. And remember, we talked about that earlier. The copyright in songs and the copyright in recordings are separate. So here we have copyright in the lyrics, we have copyright in the music, we have copyright in the sound recording, we have copyright in the video, and there is copyright in choreography. People often say, what about the costumes? Costumes will be protected by design law. Okay, so generally costumes not copyright. There is one other copyright here, which is, pardon, sorry?
Is it the director's?
No, that would be the director's rights would be within the film. The other copyright is that this is a Vivo player, and the Vivo player works because of a load of computer code that makes the video play, and there is copyright in computer code. Okay, so behind this video is a whole load of computer code, and that is protected by copyright. Now, you can also patent that kind of technology. We mentioned patents earlier. So Vivo will have patented their video player. So there is patents in technology like that, but crucially there is copyright too. So there is copyright in computer code. There is copyright in databases. There is copyright in listings. And so those are some of the copyrights that we sometimes forget about. So just to recap here, copyright in the lyrics, the music, the audio, the video, the choreography, and the computer code that is making the video play. Finally, is there copyright in this? Okay, at least some of you murmured public domain. Okay, so the point here is, although this is written down, okay, there isn't copyright in this, okay, because this was written by William Shakespeare in the late 16th century. And the key thing to know about copyright is copyright runs out. So trademarks usually last forever, providing you continue to use the trademark. If you stop using it, it lapses. But other forms of intellectual property run out. Okay, patents run out, design rights run out, and copyright runs out. Actually, copyright lasts for quite a long time, okay, but eventually it runs out. How long copyright lasts for varies from country to country, and it quite often varies depending on the kind of copyright. So generally, the copyright in songs lasts longer than the copyright in recordings. The copyright in songs is usually the life of the creator and then another period of time. Okay, so in Europe it's 70 years, in some countries it's still 50 years after death. Okay, so with songs, so the lyrics and the music, it's the life of the person who created it and then another period of time, 50 to 70 years. So if you think about it, that means if you write a hit song, okay, and it's still making money in 100 years' time, you will live off it for the rest of your life, your children will live off it, and probably your children's children will live off it. If there's multiple creators, okay, remember what we said earlier, if two people write a song together, they co-own the copyright. The general rule on copyright terms is that the 50 or 70 years start ticking when the last person dies. Okay, so if we take John Lennon and Paul McCartney as an example, the Lennon-McCartney catalogue, okay, John Lennon died in 1980, but the 70 years have not yet started ticking because Paul McCartney is still alive. Okay, and the Lennon estate will continue to earn until McCartney's death and then another 70 years or 50 years depending on the country. So aging songwriters should all work with young songwriters because then their descendants will get longer copyrights. With sound recordings, usually it's a period of time after release. Okay, it's not linked to anybody's lifetime. So in Europe now it's 70 years, in Canada it's 70 years, I think here it's still 50 years. I don't know if anyone knows that. I'm pretty sure it's still 50 years here. It's 50 years in most of Asia. In the US it's 95 years. Okay, the sound recording copyright term in the US runs longer. It's mainly because Sonny Bono, do any of you remember Sonny and Cher? So Sonny of Sonny and Cher, between being a pop star and dying, spent a time in Congress. He was a congressman in Washington. And his main achievement in Congress was to extend his own sound recording copyright terms up to 95 years. It means that the 1950s Elvis catalogue, for example, is still in copyright in the US, but actually most elsewhere in the world it's out of copyright, because although in Europe the copyright is now 70 years, that's a relative innovation. Until recently it was 50 years. So the 1950s catalogue has already expired in Europe. So in Europe you can use the Elvis catalogue without going and getting a license from Sony, who own the recordings. You would still need to get a license for the songs, remember, because the song copyrights last longer. But you wouldn't need to get a license for the recordings. However, in the US you would. So if I was to put Elvis recordings on my website, and I got a mechanical rights license, so I was paying the publishing, in Europe I would be fine. But in America, I could be sued. So I would have to make sure that no one in America could access my website. It's also worth mentioning, while we're talking about public domain, if you remaster a recording, arguably a new copyright exists in the remastered version. It sort of depends on quite how much remastering goes on, but there was a landmark ruling in the US on this very recently. So a remastered recording creates a new copyright. For that reason, in the early 2000s, Sony deleted every copy of Elvis's recordings from the 50s and put out a whole load of remastered versions. So it's really hard now to get the original Elvis recordings because they're out of copyright, but the remastered versions aren't. But if you had one of the original 50s recordings, then you could copy that and perform it without getting a license because it's out of copyright. And once something is public domain, it means that all of the controls that come with the copyright that we're going to talk about this afternoon stop. And from that point onwards, anybody can do anything they like. So if we take Shakespeare, I mean, actually, when Shakespeare was alive in the 16th century, copyright, there was no such thing as copyright. Hadn't been invented yet. But even if it had, okay, Shakespeare's been dead a long time. It would have well expired by now. And it means that anybody can perform these plays. They don't need anyone's permission. They can adapt them. They can set them in space. They can turn it into hip hop. They can do whatever they like with these scripts because they're not in copyright. Every time big copyrights are coming up for expiry, so I mentioned that the sound recording copyright in Europe was 50 years after release. And then people in the UK realised that the Beatles were about to come out of copyright because the Beatles started releasing in 1962. The UK record industry still makes a lot of money from the Beatles. And so the UK record industry lobbied hard to get an extra 20 years of protection, and they got it. So the music industry, and indeed the entertainment industry, Disney in particular, every time a Disney film is about to come out of copyright, Disney write a blank check to a lobbyist and they go and get copyright extended. Copyright extension is controversial. There are a lot of people who think the The principle of copyright is you get a period of protection, you make back your money, you make a profit, and then it belongs to society at large. So whenever the music industry fights for a longer copyright, it's controversial. That said, the European music industry would say it's mad that copyrights in the US are longer than in Europe. We live in a global economy, and the US industry now has an unfair advantage over everybody else. So there is an argument for saying that we should harmonize copyright terms across the world, because otherwise one region has an advantage over the other. The problem with that is that the US industry will keep getting those terms extended forever. But crucial thing to remember is copyright runs out eventually. Okay, so let's run through the copyright basics. Some of this is repeating what I've already said, some of it you may already know. But let's just very quickly remind ourselves of the very basic facts about copyright. So first things first, copyright is a form of intellectual property, as is patents, trademarks, and designs. I've said this several times today. Generally, copyright is an automatic right. The minute you write a song, the minute you make a recording, a copyright exists. With trademarks, you have to register. Patents, register. Designs, register. Copyright happens just by writing a song, just by making a recording. The exception being the US. There is some copyright registration in the US. So you need to be aware of that if the original place of publication is the US. However, if your original place of publication is Barbados, you still get protection in the US under US copyright law without registering. Okay, so really you only need to register if the first place of publication is America, or indeed you are an American citizen or an American company. But the general rule of copyright is that there is no registration. Every country in the world, pretty much, any country in the world where you can make money out of copyright, has a copyright system. And that system will begin with a piece of law. Okay, so every country has its own copyright law. Here in Barbados, it's the Copyright Act of 1998. So that's the last time copyright law was amended and updated here in Barbados. Copyright law here is very much based on English copyright law. And what you find around the world is often copyright law is either based on the English system or the French system. And the two are actually quite different. And if you go into mainland Europe, a lot more of the copyright systems in mainland Europe are based on the French system than the English system. And suddenly you'll start coming across things that are a bit peculiar to us from the UK, from the US, from Canada, from places, basically places that have a historical connection to English law. But here in Barbados, it is the 1998 Act where all of these rules come from. And what the copyright law does is it sets out various criteria about what gets copyright protection, and then it says what that protection means. So the answers to most of the questions in that quiz will be contained in the copyright law of your local country. So if you're claiming copyright protection in your song or your recording or whatever it is that you have created, the first question you have to ask is, do I fulfill all of the criteria of the local copyright law? In terms of what has copyright protection, again, this list varies from country to country, but generally you can identify 8 different kinds of content that have copyright protection. And this is set out in the Barbados Act, it's set out in the UK Act, and most copyright systems, one of the first things it will say in the Act is these are the kinds of content that have copyright protection. And the 8 that most systems refer to are literary works, which is basically anything written down, dramatic works, which is scripts, it's screenplays, it's choreography, musical works, which is musical composition, artistic works, which is works of art, but it also includes things like photography, sound recordings, which are sound recordings, films, which are films. Broadcasts are usually defined very narrowly. So generally, webcasting doesn't come under broadcasts. But usually, anything that goes out through a traditional TV or radio network, a separate layer of copyright exists in the broadcast, in addition to the copyright that will almost certainly exist in the recording and the video, and if it's radio, in the lyrics and the music that is going out. Typographical arrangement is basically page design. Okay, so it's when we print stuff, it's the design on the page. In terms of the music industry, the music rights, the core music rights are these 3. Okay, so there is copyright in lyrics, which is a literary work. There is copyright in musical scores, which is musical work, and there's copyright in a sound recording. Okay, so when we talk about music rights, those are the three copyrights that we're talking about. The copyright in lyrics and score, and the copyrights in recording. As I said earlier today, in the music industry, we tend to lump the two at the top together and call them the song rights, or more commonly, the publishing rights. Okay, so actually, day to day in the music industry, we often don't make the distinction between the lyrical rights and the musical rights. In France, actually, the Collecting Society very much makes a distinction. When you log your work with the French Collecting Society, it forces you to say who the lyricist is and who the composer is. Lots of people coming from other countries are like, oh, I don't really know. We just went into the studio and we made a record. Who knows who wrote the lyrics and who did the music? But we tend to lump those two rights together and call them either the song rights, or actually we would probably call them the publishing rights. And then we have the recording rights, which are often referred to as the master rights. And as I said earlier, when we're looking at the music industry, you can split the music rights industry into two. Those companies that deal in sound recording copyrights, and that's the record industry, and those who deal in song copyrights, and that's the music publishing industry. So we have two sets of music rights, two sets of music rights companies, and if you are an artist who create both, and actually these days most artists create both. There are some people who just write songs, there are some people who just record songs, but most people do a bit of both. Nevertheless, it is very common for those artists to do two deals. They do one deal with a publisher for their song copyrights and another deal with a label for their recording rights. And in most countries, actually some smaller markets like here, you can join one collecting society for both sets of rights. But in most countries, bigger countries for certain, once you get into collective licensing, that we're going to talk about later, the record industry has one collecting society, and then the publishing sector has a separate collecting society, and they operate quite autonomously from each other. Now, let's remember that the music industry actually creates all sorts of other copyright. And we talked about this earlier, didn't we? There's copyright in photography, there's copyright in artwork. Record companies are creating that stuff all the time. So the music rights industry actually goes beyond the songs and the recordings, and we talked about merchandise and the other parts of the business that are exploiting those artistic works. However, when we talk about music rights, we are generally talking about those two core sets of rights. The copyright in songs here and the copyright in recordings here. Some other quick copyright facts. Connecting factors. We actually alluded to this earlier today. Okay, every country has its own copyright system. And that copyright system will declare how you qualify for protection. So how do you qualify for protection under the Barbados copyright system? How do you qualify for protection under the UK copyright system? So first of all, you have to be one of those 8 categories. Then there will be rules that say, well, either, so in the UK, to get direct copyright protection, you either have to be British, or it has to be first published by a British company, or it has to be first published in the UK. Actually, the first publication qualification is getting harder in the digital age. It used to be quite straightforward. There would be a physical printed publication, and that would have to come out in one country first. Bam, you've got direct copyright protection. In the digital age, things go global almost immediately. So that definition is getting harder to define. But the copyright law will say we are directly protecting anything that was basically created and published in our home territory. However, as we said earlier, copyright's global. If you write a song, you want to make money out of it worldwide. And so all the copyright systems in the world are linked together through global treaties. And the big two, there are others, but the big two that people talk about are the Berne Convention and the Rome Convention. The Berne Convention covers song copyright, and the Rome Convention covers recording copyright. And what these conventions say is that all the copyright systems who sign up pledge to protect each other's works. So UK and Barbados, we're both connected through these treaties. So the agreement is, okay, the UK will protect everything that got protection under the Barbados copyright system, on the condition that the Barbados copyright system protects everything that got direct protection under the UK copyright system. And so you get direct protection from your home country and your home copyright system, but in doing so you get protection in most countries around the world. Not all, but most countries around the world. However, the protection elsewhere in the world is subject to the local copyright law. Okay, so you can only enforce your rights as far as local copyright law goes. The convention set certain minimum standards. So if you want to go and sue someone in India because they infringe your copyright, you have to do so under Indian copyright law, even though you started off with Barbados copyright law. However, you have certain minimum expectations of what Indian copyright law will do based on these treaties. And technically, they will comply with all of these treaties. Technically, all those minimum standards will be met. Whether you can then enforce them in court is another matter entirely. But technically, the local copyright laws will comply with the minimum standards. Another key point is originality of expression. This goes back to what I was saying about my news article. The copyright is in the expression, not the facts. So there has to be originality of expression. You could take my Led Zeppelin story and rewrite it. And then A, you wouldn't infringe my copyright, and B, there would be a new copyright in what you had written. But the copyright is in the originality of expression, not the facts, not the ideas, in the exact way that it is expressed. Fixation is the other point I mentioned about the fact there isn't copyright in what I'm saying now. In order to get copyright protection, your work has to be captured and fixed. So it either has to be written down or it has to be captured in an audio recording or a video recording. Okay, so if you go on the piano and play a great bit of music, but it's not captured anywhere, then there's no copyright in what you just played. You have to either write it down or record it and capture it in order to have the copyright protection. Okay, so I'm going to talk through the copyright controls, and then I might see if there's any questions on what I've covered so far before we get into ownership and collective licensing. Why would you want to own copyright? You want to own copyright because of the copyright controls. So here in Barbados, arguably, Section 9 of the Act is the most important section, because what Section 9 says is what controls come with the copyright. So the section says that if you are the copyright owner in a song or a recording or whatever, you have the exclusive right to copy the work, issue the work, perform the work in public, broadcast the work, and make an adaptation of the work. Now, the exact list of controls varies from country to country, but most copyright systems have more or less the same 6 kinds of control. Okay, so this is what I call the copyright controls. So usually what copyright is providing you as a copyright owner is with the reproduction control, distribution control, the rental control, the adaptation control, the performance control, and the communication control. In Barbados, actually, at the top of the Act, there isn't a rental control like there is in UK law, although lower down the Act, it then starts talking about rental rights for certain kinds of copyright. So it is hidden there lower down in the Act. So these are the 6 core controls that come with copyright. As I say, varies from country to country. In some countries, it varies according to the kind of copyright. In some countries, not all of those 8 categories of copyright get all 6 controls, but usually they do. And so what this means is that if you own the copyright in a song, only you can reproduce it. Only you can distribute it. Only you can rent it out. Only you can adapt it. Only you can perform it in public. Only you can communicate it to the public, which usually means broadcast, sending it out through TV or radio. If anybody else wants to do any of those things, they have to come to you for permission. And that's how you make money out of copyright, because you sell them your permission. Now, pessimistic, but worth pointing out that most songs that have ever been written and most recordings that have ever been made, nobody wants to reproduce them. Nobody wants to distribute them. Nobody wants to rent them, adapt them, perform them, or communicate them. And if that's the case, your copyright is worthless. You can't make any money out of your copyright. But the minute somebody wants to reproduce it, distribute it, rent it, adapt it, perform it, or communicate it, now you can make money out of your copyright, because they have to come to you for permission, and you sell them your permission. So that's how copyright makes money. These controls come with the copyright. If other people want to exploit those controls, they have to come to you for permission, and you sell them your permission. On what terms you sell them your permission depend on a multitude of factors. Okay, you might make $1, you might make $1 million. Okay, but the principle is the same throughout. These are your controls. If anybody else wants to exploit those controls, they come to you for permission, and that's how you make money out of copyright. Now, in the music industry, we quite often lump the 2 at the top together and call them the reproduction rights, or actually we probably call them the mechanical rights. So music publishers would definitely use the latter expression. So when music publishers talk about mechanical rights, what they're talking about is the distribution and reproduction controls packaged together. Okay, I am a record label. I want to release a recording of your song. In order to do that, I need to make a reproduction of your song, and then I need to distribute the CDs that I've pressed. So I need to get permission to both reproduce and distribute your song. So therefore, I need to secure a license for the mechanical rights. And so I come to you and get a license, or actually I would probably go to COSCAP, because generally mechanical licensing of cover versions is licensed through the collective licensing system. The two at the bottom are also often lumped together and are called either the performing rights or, increasingly and irritatingly, I think, the neighbouring rights. So when people talk about the performing rights, they're generally lumping together the performance control and the communication control. In publishing, they're called performing rights. Increasingly in the record industry, they're referred to as neighbouring rights. That's confusing because in French copyright law, neighbouring rights means something totally different. So I try not to use the term neighbouring rights, although the industry does. And when people talk about neighbouring rights in the record industry, they're talking about the performing rights, the communication and performance control of the sound recording copyright. So just to restate this. You make money out of copyright when people want to exploit your controls. So if there is someone who wants a copy of your recording, you can do one of two things. You can either make the copy for them. So I have the reproduction control, I'll make the reproduction, and I'll sell it to you for $10. And you may or may not take that deal. So that's what I call direct exploitation. Okay, I'm directly exploiting my copyright by I am using the reproduction control and selling you a copy of the reproduction. Or I can give you permission to do it yourself. Okay, there's a copy of my master recording on Apple's server. You make the copy by downloading it or streaming it. I'm not going to do the copying, you do the copying, and I'll give you permission. And permission giving is licensing. I will charge you £1 for a download, a penny for a stream, and I give you permission, I license you. And increasingly, the music industry is in the licensing business. It used to be that the record companies were primarily in the direct exploitation business. They were primarily in the business of making copies of their recordings and selling them on CD or vinyl or cassette or whatever. Whereas increasingly, record companies are giving other people permission to make copies of their recordings, either through download or through stream. The publishers have been predominantly licensing businesses for decades. May I say, 100 years ago, you made money out of song rights by printing sheet music. Direct exploitation. These days, you make most of your money giving permission to record companies or to radio stations or to streaming companies who want to make copies or performances or communications of your songs available. So the music industry is increasingly in the licensing game. Before I get into ownership and collective licensing, I will take some questions on what I've covered so far.
Hi. You mentioned earlier about trademarks and stuff. And if I wanted to register a trademark, I need to do it in each territory I'm moving into. But I just want to make a correction. It's once the territory is a signatory to the Madrid Convention, you just do a one-stop registration, and it's covered wherever the Madrid Convention is used by a territory. So I just wanted to add that to what you were saying.
Okay, so there is some sharing of trademark registering going on, yeah. is what you're saying. Okay.
Sure.
No, so WIPO, or the World Intellectual Property Office, it's a affiliate of the United Nations, and where global treaties are negotiated around intellectual property, they are administered and negotiated through WIPO, and then WIPO communicates them. However, global treaties have no power within each country. Okay, so as a country, when I sign a global treaty, I then have to go back to my home country and implement what I have just agreed to, and so you would have to go to your parliament, pass it through, and obviously the government could say to its parliament, we have to introduce these because we've just signed a global treaty, but until it has been enacted locally, then it doesn't apply, and often there will be a time limit by which those things have to be applied. And what often happens with global treaties is it's very hard to agree anything globally. So what happens is the global treaties are always written in incredibly ambiguous terms, so that two people in the room who actually disagree with each other can both sign the treaty thinking they got what they want. And what that means is they then go home and they implement what they have agreed to. So although in theory it should be the same bit of law because it's global, they implement it quite differently. So the attempt of WIPO, and in the European Union has a second layer of this, is to harmonise copyright so that copyright has lots of consistencies worldwide. And some of that has been successful, but some of it not. So for example, in the 1990s, an extra control was added. So the 6 controls that we looked at, an extra one was added in the 1990s called the making available control, or the making available right. And basically what that was about was the record companies went to WIPO and said, okay, internet's here. What happens if somebody puts some music on a server and then other people start downloading and streaming that content? And the person who owns the server says, well, I'm not doing the copying, and I'm not doing the distributing, and I'm not doing the communicating, because all I've done is put it on a server. And now everyone else is doing all the other stuff by downloading it. And so what the record companies wanted was the mere act of making the content available was protected by copyright. So the mere act of putting it onto a server without permission was copyright infringement. And so that was negotiated in the 90s through a WIPO agreement. I forget the exact treaty, but there's a 1990s WIPO treaty where the making available right was applied. Then you go and have a look at how it was applied in every country. And it has been applied very differently in different countries. In the UK, it has been explicitly put as a subset of the communication control. So it's not a new control. It's just an extension of the existing communication control. In some other countries, it's been put as a separate line. In some other countries, it wasn't actually explicitly added. They just said, oh, it's sort of covered already. So in France, for example, it wasn't explicitly added. The French government just said, all right, it's sort of already covered. So it's interesting to see how it was implemented. It's my belief that everybody implemented making available wrong. Actually, what was intended in the 90s is not what ended up in copyright law, but that's just my academic opinion. So that's the problem with global treaties. But you're right, WIPO is an organization to watch, and where there are global treaties, they are negotiated through WIPO and ultimately communicated through WIPO. Another question?
I have a question from one of our online
Yes.
viewers. They're asking, can the ownership of a master be split?
Yes. Okay, we're going to come on to ownership in a minute, but yes, ownership of master can be split in the same way ownership of songs can be split, but that's for the people who released the record to agree. So 2 labels can agree that they're going to release a record together and they're going to own the copyright 50-50. But the copyright law doesn't really have any opinion on that, except that it can be co-owned. It happens a lot more in publishing than it does in recordings, but it could happen either way.